What is the better option for you and your partner? Is it a fiance visa or a spouse visa leading to a green card? Now, both of these options have a lot of things in common. And I get this question all the time from my clients about which option might be better for them. The spouse visa option, the fiance visa option. So we're here today to talk about the two different options, the pros and cons of each, and a little bit about the process. So if this is you and you're trying to decide if you should try to come to the United States as a fiance, or if it would be better for you to go ahead and get married and then do the green card process as a spouse. So let's get started. Okay, first, a couple things about each of these visas. There's a lot in common if you're going to pick between the fiance visa or the spouse visa option. For both of them, you have to prove that your relationship is bona fide, which is the legal word that means legitimate. So for either option you choose, you're going to need to support your application with a lot of evidence about how you and your partner met, your history together, the kinds of things that you've spent your time doing, how you know each other's families, your plans for the future, and anything like that. In whichever path you choose, you're going to have to show your marriage is legitimate. And marriage fraud is a big deal with the US government. So there is a lot of scrutiny placed on this particular kind of requirement to make sure that your marriage is really a real marriage. So don't think that if you go the fiance route, it might be easier. If you go the spouse route, it might be easier. For either one, your marriage is going to come under scrutiny and you're going to have to prove that it really is a real marriage. Now, I would say 99% of the people I meet with are in real marriages. Most people aren't trying to trick the government just to get their green card, but nonetheless, you don't want to assume that the government knows that about you. You have to prove it. So either path you choose, spouse or fiance, you're going to have to prove your marriage is real. Now, either path you choose, you're also going to have to prove that the immigrant is eligible for a green card. For both of these processes, the first step is proving your relationship, but later you have to prove the immigrant themselves is eligible for a green card. The fiance or spouse visa, neither one of those gives you like an easier route to a green card. At the end of the day, to get your green card, you have to prove the same things. So if there are any issues with admissibility, marriage fraud, immigration fraud, criminal history, any of those things in your past, one or the other route isn't going to give you a better chance of getting your green card. Something else that's the same with both of these kinds of cases is that you can petition for children. So if, say, you're a US citizen or resident and you are married to an immigrant who has children, you can petition for the children as well. Now, the age of the children matters, and when you got married matters, and where you're living matters. So there's a different process depending on all of those things, but there is a way to petition for the children of the immigrant as well if you're marrying somebody who has children. So that's exciting because family unification is beautiful. So it's really nice that regardless of the method, the families can stay together. And I think that's all I wanted to tell you guys about the similarities between them. So, but now let's talk about the differences. And if you guys have any questions, pop your questions in the comments and we'll answer them, or send us a direct message if you don't want to put your comments out publicly for everybody to see, and we'd be happy to answer those directly to you as well. So in general, when you're deciding between a fiance visa or a marriage visa, for the vast majority of couples, the marriage visa is going to be the better option. The fiance visa is more complicated, more time-consuming, more expensive, and more restrictive. It has more rules around it. So while there may be limited instances where the fiance visa may be better for a particular couple, a particular time, a particular location, generally the spouse visa and the spouse green card option is going to be better for almost everyone. And then when I meet with clients, that's what I tell them as well. Now, some of that has changed a little bit with coronavirus and the time that things are taking. That has thrown sort of different considerations into the mix. But even so, the marriage green card is still a better option for most people as opposed to the fiance visa. So let's talk about the fiance visa so you know what it is and what it is not. The fiance visa is only for people married to US citizens. I'm sorry, people engaged to US citizens. The fiance visa is only available for people engaged to US citizens. Only US citizens can petition for their fiancés. If you are a lawful permanent resident, a green card holder, or if you're married to a lawful permanent resident, a green card holder. Sorry, engaged. I keep saying married because that's the option I think is better. We're talking about fiancé visas in case you want to learn more about them. But as I said before, I don't think they're great. The marriage option is usually better. But fiancé visa is only available for fiancés of U.S. citizens. Residents, green card holders, cannot petition for their fiancés. So you have to be married to a green card holder before you can petition for any status as an immigrant spouse of a green card holder. So fiancé visas are only for spouses of fiancés of U.S. citizens. You have to apply from abroad. If you're already in the U.S., you can't apply for a fiancé visa. That doesn't make any sense for you. So you're only applying for a fiancé visa if you are living abroad and you're asking for that visa to enter the country. The only thing you can do with a fiancé visa, the only thing you can do is enter the country and marry the person who petitioned for your fiancé visa. You can't choose to do something else once you get here. You cannot choose to marry somebody else. You cannot choose not to get married and stay. If you enter on a fiancé visa, that's the only reason you get to come to the United States, and you have got to get married within 90 days of getting here. You may have heard of a show called 90 Day Fiancé, and it plays on this concept. Those relationships, I haven't watched the show very much, so don't really know, but those relationships are not just 90 days long. The idea is that they only get 90 days together in the country before they get married. So if you enter on a K visa, which is a fiancé visa, you must get married to your U.S. citizen fiancé within 90 days of getting here. And then, only then, after you've gotten married to your U.S. citizen fiancé inside the United States, can you start the green card process. And this is one of the reasons why the fiancé visa process is frustrating, longer, more complicated, more expensive, because you have to do this whole first part of getting your fiancé visa, getting inside the country, getting married, and then you start the green card process, which is the same as if you would just start the green card process from the beginning. There's some different steps, but you're essentially adding on that whole complicated part at the beginning of getting your fiancé visa that you don't have to do if you just get married before you apply for your status. Okay, another critical thing to know about the fiancé visa is that you're not going to get to work when you enter the United States as a fiancé of a U.S. citizen. When you enter the United States with a K visa as a fiancé of a U.S. citizen, you have no work authorization. Getting your work authorization can take a really long time, months, a year, a really long time. Depends on your particular case. Each case is unique, but nobody with a fiancé visa has work authorization at the moment they enter the country. And so that is a major reason why for many clients of mine, the fiancé visa is not the best option for them, because the immigrant wants to be able to continue their life, continue their work, continue their career. If it were me, I wouldn't want to enter the country and just wait around, not getting to do my work, not getting to live my life. So if on a fiancé visa, you have to be comfortable entering the country and not working for a while. Okay, so those are all the sort of downsides of the fiancé visa. The upside of a fiancé visa is that sometimes it does move more quickly than the spousal visa process. And so it can be a way to get your fiancé into the United States a bit faster. Now, that's not always the case at all. And so if that's something that's really important to you, you can try it, but there's no guarantee that you're going to be able to enter the country more quickly as the fiancé of a U.S. citizen than you would as a spouse of a U.S. citizen. So keep that in mind. Each processing times change wildly, and they're always changing. And each consulate itself has its own processing times and the own way that they handle cases. So a case could take 3 months in London, and it could take 9 months in Ciudad Juarez in Mexico. So where you are living, which consulate you're going to process your case through, makes a big difference in your time processing too. So it's really important that you consult with an attorney before you make a decision about which route to go on, because that attorney will be able to tell you, like, okay, for your case and your location and the things that matter to you, fiancé visa is better, spouse visa is better. But so those are some of the things to keep in mind when making that decision. So that's the only slight upside of the fiancé visa is sometimes in some cases, you may be able to get to the United States more quickly than if you went through the spousal visa, spousal green card route. But it's not always the case, and it's not a guarantee of faster processing. So keep that in mind. The biggest downside I see for my clients is that when you enter the United States as a fiancé, you don't have work authorization. That K-1 visa does not give you work authorization and can take you a while to get it after you've entered the United States as a K-1 fiancé. Okay, let's talk about marriage visas. Marriage visas are available to both U.S. citizen spouses and green card holder spouses. So while the K-1 Fiance Visa is only available to fiancés of U.S. citizens, spousal petitions, spousal green cards, are available for U.S. citizen or green card holder spouses. So it opens up a much wider world of people who are available for this process, who can go through this process to get their status. You can apply from abroad or within the United States. If you are living abroad and you are married to a U.S. citizen, you can apply from abroad. If you're in the United States, you can apply from within the United States. You may be able to stay here through the entire process. You may have to leave at some point and go to a consulate to process your visa, and that depends on your particular immigration and employment history. And that's something we can talk about in your case if you want to learn more. But you can apply from within the United States. There are 2 steps to get your spousal green card. The first step is you have to prove your marriage is legitimate. And so you'll notice this is the same as the Fiance Visa petition. In either case, there's going to be a point in the process where you have to prove that you have a real marriage. Marriage fraud is a real concern for the U.S. government and the immigration system. They have an entire department dedicated to marriage fraud and to making sure that people petitioning for spousal visas are really in legitimate relationships and they're not applying just because they want a green card. Now, getting a green card can be a major benefit that you can be really excited about. You don't have to pretend that it's not a good thing, but it can't be the only reason for your relationship. You have to otherwise have a legitimate, real relationship that revolves around something other than immigration status. So you have to prove your marriage is legitimate. The second step in either of these cases is proving that the immigrant is eligible for status. Now, what does that mean? There is a very long list of reasons that someone might not be eligible for a green card. They include things like immigration violations and negative criminal history, all sorts of things. There's a really long list that we have to go through to make sure that you are eligible for a green card. So that's step 2 in the marriage green card process. Step 1, prove you have a real relationship. Step 2, prove that you, as the immigrant, are eligible for your green card. Okay, so the really good part about the marriage visa process is that if you're living abroad and you apply for your marriage visa from abroad, then that whole thing is going to be processed abroad. Step 1 and step 2 are all happening abroad. You'll go to your interview at the consulate. They will approve your case. And when you enter the United States, you enter as a lawful permanent resident and you have work authorization. So the moment you enter the country as a spousal green card holder, you can work. You don't have to wait. So you can keep living your life without interruption. Continue to have that control over your own career, your own destiny that I know you want to have. So that's a really positive part of the marriage green card process that isn't available to fiance visa holders. You get to work as soon as you enter the United States. All right, let's see. What else should we talk about? Okay, so let's go over some issues that arise frequently with both marriage and fiance visa cases and with really any immigration case. So what are the major things that I want you to be aware of and to look out for as you're thinking about your marriage, your fiance or marriage visa case? The first we've talked about a couple times. I want you to be aware of marriage fraud. It's a real and legitimate issue. The U.S. government looks very closely at marriage-based green card cases, and that includes the fiance visa cases because those will lead to a marriage-based green card case, to make sure that your marriage is legitimate and is not only to get a green card. So it's really important to be able to prove the legitimacy of your marriage. Okay, another issue that comes up frequently in these cases is immigration fraud. So you're hearing all this stuff about fiance visas and marriage visas, and you're thinking, why can't I just enter the U.S. on my visitor visa, and then I'll marry my U.S. citizen spouse or fiance when I'm in the U.S., and then we'll do the green card process once I'm in. I get that that feels like an attractive option, and you may have even had somebody tell you that that's okay because there are notarios out there who will lie to you and tell you that that's okay. That is immigration fraud, and you cannot do that. You may not ever enter the United States on a B2 visa for the purpose of getting married to your U.S. citizen or lawful permanent resident fiance and staying in the United States. You can enter to get married here if you're planning to leave again. The person at the border may or may not believe you that you're planning to leave again, so they may or may not let you in. But if you purposely enter the United States with a visitor visa solely to get married and stay here, that's immigration fraud, and it's going to cause major problems for your case, and you may not ever be able to get your green card. So do not do that, okay? It's possible you can go find some stuff on the internet with some other person telling you that they've been able to do that successfully, or some other attorney or notario telling you that that is okay. It is not. If you hear nothing else today, I want you to hear you may not enter the country on a B2 visa for the purpose of getting married and staying in the United States. It's marriage fraud, and the government will absolutely cause a problem for you in the future. Okay. Other issues that could arise in your case. If you have any negative criminal history, we're going to want to look at that really closely. Any arrests at any time in any country, whether you were underage, whether they've been expunged, whether you don't think they're a really big deal, immigration might think that they're a really big deal. And the way in which immigration considers and cares about criminal history isn't very logical or obvious. So it's really important, really important. If you've had any contact with law enforcement in the past, you really need an attorney on your case, because it can really negatively impact you, and you don't want to get a denial, end up in deportation proceedings, or never be able to immigrate to the United States because you didn't realize that you needed to handle that criminal history in a certain way. Any negative immigration history. If you've ever had a negative encounter with immigration officials in the United States, that could cause problems for your future fiance or spousal green card case. So I want you to be really cautious about that. If you've ever been pulled into secondary inspection at the airport, if you have ever been denied a visa ever, if you've ever lied on an immigration application, whether or not you think anybody knows about it, if you've ever been caught at the border trying to enter undocumented, whether or not you think anybody knows about it, I want you to be real cautious, because that could cause a real problem for your case. So any negative immigration history can complicate your case. And it's really important that you have an experienced immigration attorney analyze the issues in your case before you move forward. Something else that comes up all the time in fiancé and marriage visa cases is the affidavit of support. You've probably heard a little bit about the public charge rule and the affidavit of support. If you've done any research around fiancé and spouse visas, you've probably come across this. Anytime somebody petitions for a family member, the US citizen or the resident who's petitioning for their family member to get a green card has to prove that they, the US citizen or the resident, can financially support the immigrant that they're petitioning. And so that can be a real issue in these cases. If you have any concern that the person who's petitioning you doesn't have a very high salary, or doesn't have a lot of assets to be able to prove their financial stability, then you may need a joint sponsor. And that's completely permissible, but it does create additional risks, additional time, additional expenses in your case. And you want to be quite cautious about who you pick to be your joint sponsor, how you know them, the information that they provide, and that they really understand the commitment that they are making to financially support the immigrant. When somebody sponsors an immigrant, they are actually entering into a contract with the US government to financially support that person. And the US government can come back and seek repayment of any public benefits that the immigrant receives from the sponsor. So it's really important to know that it's a formal contract with the US government, and it's not to be taken lightly. It's a real responsibility. I want to mention briefly the expanded public charge rules. In the last year, the Trump administration, not the last year, in the last 4 years, the Trump administration has really expanded the way in which the public charge rule is applied in family-based green card cases. And that applies to fiancé and marriage cases. The public charge rule is what encompasses the stuff we were just talking about the financial affidavit of support. So the public charge rule is what governs all the financial requirements related to your green card case. So the Trump administration has expanded and expanded and expanded and expanded what the public charge rule looks like to require additional forms, additional evidence, a more time-consuming process, a more intense process for both the petitioner, which is the US citizen or resident, and the immigrant who's coming to the United States. The Biden administration has indicated that they will likely roll back that expansion of the public charge rule. They are in the process of reviewing the expansion of the public charge rule and its application to determine if and how to undo those changes. So we expect quite a bit more information about that in the coming weeks and months. Right now, nothing has changed very drastically, but we expect that it will going forward. So that's just something to keep in mind, that the expanded public charge rule under President Trump really increased the amount of scrutiny placed on the finances of both the petitioner and the immigrant. but that could be changing in the near future to return to the more traditional application of the public charge rule, which focused primarily on the income and assets of the U.S. citizen or resident family member seeking status for their spouse or family member. All right, so that's just a high-level review of the fiancé visa versus spouse visa. Which is better for you? As a reminder, like we talked about at the beginning, for my clients, almost always, the spouse green card option is going to be better than the fiancé visa option. Each case is unique. It's really important to have your case properly analyzed by an experienced immigration attorney. Don't go to a notario. Don't go to somebody who does 16 different kinds of law and sometimes maybe does immigration law. Immigration law is really complex. And if you mess it up, you can really mess up your future ability to live and work legally in the United States. It's really important that before you choose which option is right for you, you speak with somebody experienced in this area who can listen to your story, your goals, your desires for you and your family, and help you understand which option is right for you. Neither option is bad. The fiancé visa is great. Marriage visa is great. They're both available options that can really benefit a lot of families. You just have to figure out which is going to work best for your family in your situation, depending on your goals. Give us a call if you have any questions, 512-675-2945, or check out the other videos we have on our YouTube channel. We have a lot of information about marriage cases, green card cases, and a lot of other immigration cases in case you're interested. And everybody at the firm is bilingual in English and Spanish, so we would love to talk to you in whatever language is best for you. And I look forward to seeing you next week. Bye.